Hello, everyone. In this lecture, we're going to talk about the framework of judicial review. And our purpose is to provide an overview of judicial review. We will obviously be exploring the concept of judicial review deeper in the succeeding weeks, but for now, it's going to be good to have a good overview, a bird's eye view of what judicial review is all about. And at the end of this session, you should therefore be able to discuss and explain the concept of judicial review and when it is available to review administrative decisions. You should also be able to distinguish judicial review from merit review. You should also then be able to discuss and explain the framework and legal basis for judicial review in Australia, particularly referring to judicial review of Commonwealth administrative decisions, and then discuss and explain the requirements of justiciability in judicial review and why the issue of justiciability is important. So let's begin by talking about the concept of judicial review. Obviously, you'd probably have heard that judicial review involves a review by the courts of administrative decisions. And we talk of administrative decisions, we're talking of decisions made by the executive. So we're not dealing with decisions of the judiciary or decisions of parliament. We're talking of decisions of the executive. Now, that is a crucial point because when we say that the judiciary attempts to review a decision of the executive, it seems to tell us that there is an attempt on the part of the judiciary to kind of supervise decision-making on the part of the executive. It makes us begin to think that the judiciary seems to be in a higher position in the scheme of government, in that it is in a position to actually review decisions made by the executive. Now, but that would be the wrong way of looking at it. The judiciary, when it exercises its power of judicial review, is only there for the purpose of trying to regulate or control or act as a check on the power of the executive. But it is not attempting to assert a claim that it is over and above the executive. And this is the reason why we will later see that judicial review focuses solely on a review of the legality or lawfulness of the decision of the executive. It actually does not attempt to review the decision itself. Now, we will need to clarify that notion in a short while. But for the purposes at this time, let's be clear that when we talk of judicial review of administrative decisions, the focus of the judicial review is on the process by which the decision is made. It is not about the decision itself, whether the decision is correct. It's not about the merits of the decision. That is important because in the Australian system of government, you would have heard of the notion of separation of powers. And there are three key branches of government. You have the executive, you have the judiciary, and then you have the legislature. Now, these three branches of government are meant to be co-equal. None of them is superior or over and above the other. Now, it's also important to consider that whereas Parliament or the legislature and the executive have a claim to be representatives of the people because they have been elected into office. So in a system of representative democracy, the members of the executive or the members of the parliament can claim to be the voice of the people. The courts cannot make such a claim because obviously the members of the judiciary are appointed into office. So it's crucial, therefore, that in the system of separation of powers, each branch of government learns to respect the powers given to one another. And this is the reason why, as we will later see when we talk about justiciability, there are points or times when the judiciary will not seek to review a decision of the executive out of deference for the executive because the executive is supposed to wield the mandate of the people. And the executive is oftentimes in a better position to determine policies as far as government is concerned. it is the executive that sets the agenda of the nation, and it's not the judiciary. So therefore, as we will see later on, because of the notion of separation of powers, there are certain issues or certain matters that the judiciary will not seek to review. So going back to the notion of judicial review, so judicial review concerns a review of administrative decisions or decisions of the executive. It is not a review of decisions of the judiciary or of the legislature. Now, because of the notion of separation of powers and the purpose of judicial review is primarily to act as a check or as a control on the exercise of executive power, and it is not an attempt to second guess decisions of the executive, in the exercise of its power of judicial review, the courts do not seek to substitute the decisions of the executive. Okay, in general. As I said, we're going to go deeper into this in a short while. But in general, courts do not substitute the decisions of the executive. Courts only look at the legality or lawfulness of the decision. So what therefore happens is that even if a decision is unlawful or a decision is contrary to law, and it would appear that having to remit the case back to the original decision maker, is such a waste of time or is such a waste of money, that will have to be the way it is. Because courts, when they exercise judicial review, that power of judicial review is very limited. It is limited to a review of the lawfulness or legality of decision making, looking more at the process of decision making rather than determining whether the correct decision was actually made by the executive. So, having said that judicial review is actually a limited review, the focus of judicial review, as you said, is on the lawfulness or the fairness or reasonableness of the process under review in general. That's according to the Minister for Immigration and Ethnic Affairs versus Guo. So it is not a review of the decision itself. So this is an important point because when you compare judicial review to an appeal, for example, in an appeal, a court can substitute its own decision for that of an inferior court or for that of a tribunal from which a decision has been appealed. In judicial review, however, a court can only quash or set aside the administrative decision, but it cannot substitute its own decision. So you will see the limits of judicial review. And whereas in an appeal, a court is in a position to not only look at the law, but also examine the facts of the case. In a judicial review, the focus of the review is not on the facts, but on the process of decision making. So therefore, you can see a clear limitation of judicial review. So it's not a review of the decision itself. But having said that, it is actually kind of incorrect to say that judicial review is all about looking at the process of decision making to determine if it was fair or it was reasonable. It's more than that, because actually judicial review is able to look into the decision itself, such that if the decision is so unreasonable, and when I say it is so unreasonable, that no one should even be able to arrive at such kind of decision, or what has been called witness-very unreasonableness, then in that case, that particular decision would also be considered to be contrary to law or illegal or unlawful. So in that regard, we can see therefore that judicial review, although it focuses primarily on the process of decision making, it actually is able to examine and touch upon the decision itself, especially in those cases where the decision is so unreasonable that it has to be contrary to law. Now, moving on, it's often important to distinguish judicial review from merit review. And there are various ways by which we can compare the two. From the viewpoint of a reviewing body, for example, a judicial review is always undertaken by a court. And a court, in that sense, is part of the judiciary, or what in the Constitution is called a Chapter 3 court. And which means, therefore, that it is judges that undertake judicial review. And they have to be appointed by the Governor General. And they can serve a term of office up to the age of 70. And they have security of tenure. And because of their security of tenure, you can say that judges are relatively free from interference, and they are not afraid to, make decisions, even if those decisions may be very unpopular to the executive. In the case, however, of merit reviews, the reviewing body is an administrative tribunal. By convention, an administrative tribunal is considered to be part of the executive. Some would argue that because administrative tribunals undertake judicial functions, in the sense that, they attempt to act judicially, in the sense that they observe principles of fair play, or they observe principles of natural justice, or procedural fairness, meaning they ensure at least two things. One, administrative tribunals adhere to the principle that they must always decide on the basis of fairness without favoritism or bias. And secondly, there's that aspect of natural justice, in the sense that they will always give opportunities to parties to be heard. So therefore, administrative tribunals, by acting judicially, can almost be considered to be acting in a quasi-judicial manner. However, as I said, by convention, they are considered part of the executive. And the reason for this is simple. As we said, there are three branches of government that we know of, and that is the executive, the judiciary, and the legislature. They cannot be part of the legislature, obviously, because they're not they're not involved in making laws. They cannot be part of the judiciary because they are not Chapter 3 courts, meaning their creation and the appointment of tribunal members is not in accordance with Chapter 3, and therefore they cannot be Chapter 3 courts. They cannot be part of the judiciary. And as a consequence, if they are not part of the legislature, they're not part of the judiciary, then they must be, logically, part of the executive. Chief Justice Spiegelman, who is Chief Justice of the New South Wales Supreme Court, argues, actually, that administrative tribunals should be considered part of a fourth branch of government, which he calls the integrity branch of government, together with such agencies as the ombudsman. But that's a totally different issue that we don't have to explore at this point. So let it be clear at this point that that merit review is conducted by administrative tribunals, and typically these belong to the executive. They are overseen. But for example, in the Commonwealth, they are overseen. They are within the portfolio of the Attorney General, who belongs to the executive. Now, in terms of the nature of review, going back a bit more to the issue of the members of tribunals, whereas courts have security of tenure, and judges continue to remain in their position up to the age of 70. Members of administrative tribunals typically serve only for a limited term. If you talk, for example, of the Administrative Appeals Tribunal, typically their term of office will be from 5 to 7 years, which means, therefore, that after that 7 years, they need to be reappointed. Now, this possibility of them being reappointed makes them susceptible to influence by the executive, because if the decision making is something that is not very popular to the executive, then they might not get reappointed. So there is that concern that administrative tribunals may not be as independent as they should be. Now, moving on, a third dimension by which we can make a distinction between judicial review and merit review would be that the nature of judicial review is very limited and narrow, as we discussed earlier. It focuses on the lawfulness or legality of a decision. The nature of a merit review, however, is very broad, because if you look at the scope of the review, it looks also at the correctness or merit of the decision. So in other words, in a merit review, the question is asked, is this a correct decision? You can even ask, is this a preferable decision? And these are questions that are not asked in a judicial review. And you will see that in the case of Lolor versus New South Wales, we will see as well that even in terms of merit review, the administrative tribunals are often in a position to look at the lawfulness of a decision. So in other words, the fact alone that a decision seems to be illegal or contrary to law does not mean that an administrative tribunal is divested of its jurisdictions. It can continue to examine the merit of a decision or the correctness of a decision, notwithstanding a claim that a decision seems to be unlawful. So for that reason, when you talk of a broad merit review, it means that administrative tribunals look primarily at the correctness or the merit of a decision, but incidentally, they also examine the lawfulness of a decision. Now, in terms of decisions that can be reviewed, in the case of judicial review, the administrative decisions must be justiciable. And when we speak of it being justiciable, this is an issue or a topic that we will explore a bit more in a short while. This essentially means that, one, because of the notion of separation of powers, as we said, courts will not seek to second-guess matters that are best decided by the executive. So, issues of whether or not a treaty should be entered into, or whether or not international relations should be entered into, or whether or not the executive should send soldiers to Ukraine or send soldiers to Afghanistan. So these are administrative decisions that, because of the separation of powers, courts will defer to the executive when it makes those decisions. The second aspect is that when you speak of the function of the courts are primarily meant to concern itself only with matters. And when you speak of a matter involves an actual controversy between parties. So there has to be an actual controversy, and there has to be parties involved. In other words, courts cannot undertake judicial review of something that is hypothetical, or that will just involve an opinion, or where there is actually no party that is aggrieved, and that has something to do with legal standing as well. But when it comes to merit review, administrative tribunals, they examine all types of administrative decisions, and mainly because they are already part of the executive, it's not an issue that they seem to be reviewing a decision of the executive, because that's exactly what they're meant to do. They're meant to primarily review decisions of the executive. In terms of the basis of review, the primary basis of review in relation to judicial review is the law. So courts examine administrative decisions to determine if the decision is in accordance with law. In merit reviews, however, administrative tribunals also consider the facts. They will also consider government policies. They will even exercise discretions that were available to the original decision maker. Now, these are matters. So these are, facts, government policies, and discretions. These are bases which cannot be taken into account in a judicial review. That is beyond the scope of the courts when they review an administrative decision. In terms of the process of review, obviously, if it's about a court, then courts, follow a legalistic, formal process, and therefore it's usually slow. And you usually need lawyers if you seek to have judicial review of an administrative decision. Merit reviews, on the other hand, are purposely meant to be less formal, less technical, and therefore they're quick. You don't need lawyers in merit reviews. So again, that's a major distinction in terms of the process. Now, another key point is that in terms of the effect on the decision, as I pointed out earlier, in judicial reviews, the administrative decision may be quashed, it may be set aside, but a judge cannot remake a decision of the original decision maker. He can only set it aside and perhaps remit it back to the original decision maker, who can then change his decision, vary his decision, or come up with a new decision. So even if it is very apparent to the court on what the decision ought to be, it is beyond the power of the court to say this is what the decision should be. The court does not have that power. All the court can do is to quash a decision, meaning set it aside, and then remit it back to the original decision maker, who will then review his or her own decision and perhaps substitute his own decision or change it. But the court cannot change the decision or cannot substitute his own decision for that of the original decision maker. In a merit review, however, the administrative tribunal puts itself in the shoes of the original decision maker. And because it now stands in the shoes of the original decision maker, it is in a position to actually substitute or change the decision of the decision maker with its own. So it can replace the decision of the decision maker, it can change it, it can also set it aside, and even remit it back to the original decision maker. So in other words, the power of an administrative tribunal reviewing an administrative decision is broader.